Hello, everyone. My name is Nandakumar Ponniya. I'm a principal at Baker McKenzie and I'm based in Singapore. On behalf of all at Baker McKenzie, we would be delighted if you could join us in our upcoming webinar entitled The Future of Disputes in Asia Pacific, where we'll be sharing some key updates and developments in the dispute space. As a prelude to our live event, my colleagues and I today will share commercial litigation developments in 4 key areas. 1. Technology. 2. Mediation. 3. International commercial courts. And 4. Class actions. I'm joined today by my colleagues and friends Cynthia Tang from our Hong Kong office and Yoshiaki Muto from our Tokyo office. I'll start first with technology before handing over to Yoshi. In the Asia-Pacific region, the pandemic has accelerated an increased use of online tools and remote hearings in court proceedings. My colleagues and I have handled several virtual hearings in the last year. We are seeing the developments of new rules and guidance from courts around the region, including from Australia, China, Hong Kong, Japan, Philippines, and Thailand. Common themes include electronic filing of court documents and virtual hearings. Specifically in China, many PRC courts and arbitral institutions explored virtual hearing procedures to mitigate the impact of COVID and its corresponding restrictions. Some institutions have issued online hearing rules, although certain challenges are yet to be resolved, particularly concerning witness testimony. We foresee further developments this year and expect an uptick in virtual hearings, especially in cross-border disputes. Yoshi, can I hand over to you now to provide us with an overview on cyber fraud, as well as trends in online platforms and social media?
Thank you, Kumar. Yes, the pandemic has brought a global spike of the remote working, video communication, online education, and virtual shopping. As a result, recent trend is the increase in cyber fraud cases where fraudsters capitalized on fraud in IT systems. Issues include hacking incidents combined with trade secret leakage, online fraud, and data hostage ransom targeted at companies, business organizations across jurisdictions and industry sectors. These frauds can be significant, leading to losses of tens of millions of dollars, pounds, and euros. Major challenge relate to a recovery where fraudulent proceeds of different victims may end up in chain of transfers and multiple offshore bank accounts. In Hong Kong, remedies include vesting orders and garnishee proceedings, but recent court decisions have diverged as to how best to recover stolen funds from fraudsters and subsequent recipients. In Japan, local police is empowered to issue temporary freezing orders to local banks, but it must be done very, very quickly before money has been gone to an offshore bank account. To maximize recovery, always specialist advice is essential. In another tech-related development, the Malaysian Federal Court delivered a much-anticipated judgment that provided a reminder that online platforms, news portals, website owners, social media vendors, and other online content providers may no longer be free from liability arising from publication of defamatory, fraudulent, otherwise illegal third-party content, even though they have no control over or they don't even have any knowledge about such content. The court confirmed that reliance on a quick takedown procedure and compliance with the local laws do not provide a shield for defense. In the meantime, commercial mediation continues to be the important trend in the region. The Singapore Mediation Convention is a multinational treaty which aims to ensure cross-border enforceability of settlement agreements arising from mediation, and it entered into force in September last year. We believe the Singapore Convention will bolster the uptake of mediation as an alternative means of dispute resolution in the future and may even become an integral precursor to the dispute resolution process for commercial litigation. The convention currently has 53 signatories, including US, China, and India. If ratified by many and more states, the convention will provide a harmonized framework to enforce international mediated settlement agreements across different jurisdictions, putting mediation on equal standing as an arbitration in terms of competitiveness as an alternative dispute resolution option. For instance, in Vietnam, we expect a rise in the use of pre-litigation mediation as a local law on mediation and dialogue at court took effect earlier this year. The new law formalizes the procedure for mediation and recognition of mediation results, which had been implemented in local courts in 16 provinces as a pilot program with notable success. Essentially, the new law introduces clearer and more detailed procedure to take procedure for dispute resolution in Vietnam more flexible and effective. More to come in this region about commercial litigation. Now I turn it back to Kumar for an overview of international courts and cross-border dispute trends. Kumar?
Thank you, Yoshi. With respect to international courts and cross-border disputes, a number of jurisdictions have launched new international courts or specialist divisions of existing courts. To take the Singapore International Commercial Court, or SICC, as an example, litigants benefit from many of the advantages of arbitration while keeping many of the advantages of litigation, such as the administration of multi-party and multi-contract proceedings. This year marks the 5th year since the inception of the SICC, which has since published 64 written judgments, a testament to its increasing popularity as the forum for commercial litigation. There are several proposed amendments to the SICC rules which we feel would further strengthen SICC as a popular dispute resolution forum for commercial litigation. We are anticipating an amendment to the SICC rules that proposes to grant discretion to the judge presiding over the first case management conference of a matter that would allow the judge to direct that case proceed along one of 3 tracks, either through pleadings, through statements, or memorials. The initiative would accommodate foreign parties and foreign counsel who may not be too familiar with the system of pleadings usually practiced in common law courts. We believe that the SICC will become a preferred forum for international commercial disputes due to the advantages that it has over arbitration in some aspects. For instance, where the dispute involves multiple parties and requires third and related parties to be joined to the proceedings. Another example would be a situation where parties wish to access the full array of the court's interim measures, and in cases where parties want the option of an appeal. With the Hague Convention on Choice of Court Agreements, SICC judgments are now widely enforceable throughout the world. So beyond Singapore, there have been developments in this space as well. For instance, in Taiwan, the Intellectual Property Court is set to be recognized as the Intellectual Property and Commercial Court. The new court is scheduled to become effective on 1st July 2021 and will also deal with civil commercial cases comprising certain commercial claims mostly exceeding 100 million Taiwanese dollars. This amounts to about approximately US $3.45 million. To expedite the resolution of commercial cases, new mechanisms, including mandatory counsel representation, introduction of commercial investigation officers and expert witnesses, information requests, and protective orders. The goal is to achieve the resolution of commercial cases expeditiously and professionally. I will now hand over to Cynthia to give us an overview of developments in the class actions space. Cynthia?
Thank you, Kumar. On class actions, we're seeing some activity in the region and would like to highlight 2 jurisdictions, China and Australia. China recently launched a new class action mechanism to crack down on corporate malfeasance in the securities market. Although legal actions by individual investors were previously possible, this was often difficult and costly. Under the new mechanism, the China Securities Investor Services Center a Chinese government-affiliated body can sue on behalf of no fewer than 50 investors in a company on an opt-in basis. We're watching the space and will keep you updated through our alerts and blogs. In Australia, litigation funding continues to drive class action activity and has partly been responsible for the increased regulation of funders. Australia also continues to advance in this space with the legislature, allowing contingency fees in class actions and the courts providing guidance on factors for approving a class action settlement. Those are just snapshots of the recent trends and upcoming developments in commercial litigation. Given the economic challenges posed by the COVID-19 pandemic, it has inevitably led to a rise in commercial litigation. It is therefore important to be appraised of the developments in commercial litigation. To learn more, please make sure to register and join us this May for a full discussion on these and other trends in arbitration and compliance areas. On behalf of my colleagues, Kumar and Yoshi, thank you and see you all soon.